अच्छा जी, acceptance. Only the person, नहीं acceptance से तो हमने नहीं शुरू करना था, हमने agreement से
कौन
शुरू।
सा
अच्छा जी,
agreement?
agreement. An agreement is made up of an offer and acceptance. ठीक है, ऑफर होगी और एक्सेप्टेंस होगा, दो चीजें एग्रीमेंट के लिए होना जरूरी है। उसके
हम्म
बीच में बाकी सारा एक स्केलेटन आता है जिसको हम एक एग्रीमेंट कहते हैं, वो हम बाद में डिस्कस करेंगे। लेकिन जो फर्स्ट चीज है और जो एंड चीज है वो जरूरी है। फर्स्ट इज ऑफर, द सेकंड इज एक्सेप्टेंस। ठीक
हम्म
है, ऑफर द पर्सन मेकिंग द ऑफर। ठीक है, ऑफरर कौन हुआ? जो बंदा ऑफर कर रहा है। ठीक
हम्म
है, ऑफरी द पर्सन टू whom the offer is made. ठीक है, bilateral contract, both parties assuming an obligation to to each other. ठीक है, what does this mean? This means that both parties are assuming that they have a duty of care under that contract, under that agreement, to not breach those terms. If any one of them breaches that term, they would be in breach of contract. That is a bilateral agreement, usually by making a promise to do something. So, for example, in a contract for the sale of a car, the seller makes a promise to sell his car to the buyer for a specific sum of money. The buyer, in turn, promises to buy the car and pay the specific sum of money. Now, what are the action words within this entire occurrence?
Making a promise to sell and then promises to buy the car.
So, making a promise to do something. Number one, the seller makes a promise to sell the car. That is the starting point. Then, the buyer, for a specific sum of money, agrees to purchase the car. The buyer, in turn, promises to buy the car. Now, there is an obligation, another side's obligation, the buyer side's obligation, and pay the specific sum. Now,
Hmm.
the word is specific sum. So, there is, wherever there comes a contract, it is on specific terms,
Hmm.
specific sum of money. Both
Hmm.
parties to the contract have assumed obligations towards each other. Party A's obligation is what? Party A's obligation is to sell the car.
Hmm.
The car should be present. He should be the owner of the car,
Hmm.
and the car should have a clean title.
Hmm.
Three obligations.
Hmm.
From the buyer's side, the buyer has to identify himself.
Hmm.
Oh, sorry. The seller also has to identify himself as the owner of the car.
Hmm.
The buyer needs to have a recognizable amount, not cryptocurrency,
Hmm.
recognizable and agreed amount.
Hmm.
The buyer needs to verify himself. And number three, the buyer needs to complete the purchase,
Hmm.
should he wish to proceed with this transaction, right?
Hmm.
Now, that is a bilateral contract
Both
between two
parties are
parties.
assuming. Yeah.
Yeah.
Hmm.
Unilateral contract, one party makes an offer or proposal in terms which calls for an act to be performed by one or more parties.
Hmm.
A unilateral contract does not involve mutual promise.
Hmm.
Only the person making an offer assumes an obligation. The other party accepts the offer by performing the required act in accordance with the requirements of the offer, hence creating a unilateral contract. A common example of a unilateral contract is when a person puts a notice offering a reward for a safe return of their lost pet. The person putting up the notice has assumed an obligation to pay a reward to the person who returns his pet. Anyone can accept the offer by performing the required act of returning the pet to the person who put up the notice. So,
Hmm.
one person makes the offer,
Hmm.
an unidentified amount of people,
Hmm.
they they perform or they act on that offer,
Hmm.
and it is first come first serve basis.
Hmm.
So that is also unilateral contract. Auctions are unilateral.
Hmm.
Anything you see in the market
Yeah,
is unilateral.
true.
Nowadays, Amazon is unilateral. AliExpress is unilateral.
Hmm. True. And the
Anywhere
party
you see a
accepts it.
yeah,
Yeah.
anywhere you see a product, one person is selling it,
Hmm.
the rest of the people are purchasing it.
Hmm.
It's
Good point.
sort of like
Hmm.
a buy uh, business to consumer transaction.
Hmm.
Formation of a bilateral contract.
Hmm.
Identify whether a communication is an offer or an invitation to treat. So when we're trying to identify if the question that we've been given is it a bilateral contract, we need to identify number
Hmm.
one whether a communication is an offer or an invitation to treat. Number two, is the statement by the other party a counter offer or a request for further information?
Hmm.
2a, what is the effect of a counter offer or request for further information on the original offer?
Hmm.
3, is the acceptance in response to the offer?
Hmm.
4, does the acceptance mirror the offer? 4a, where the acceptance does not mirror the offer, it raises the question whether it is a
Hmm.
counter offer or a request for for further information.
Hmm.
5, is the acceptance made using a
Valid.
valid mode?
Hmm.
Is the acceptance communicated?
Hmm.
This will be determined by the mode of acceptance used by the offeree. If the offeree sent the acceptance by post, then a discussion of a postal rule and associated issues will be relevant. If the
Hmm.
acceptance was sent using instantaneous means, such as email or fax, then that will lead to a discussion of the rule of Entros versus Miles for East Corporation and all the related issues. At the point of acceptance, is the offer still open? You will need to check whether the offer had been terminated either as a result of rejection, lapse of time, or revocation.
I have.
Invitation to treat. Sorry, uh, valid requirements for a valid offer. A valid offer must be clear, certain, and display an intention to be bound.
Hmm.
So, for a valid offer, we need three things: clarity, certainty, and display an intention to be bound.
Where is it written?
Sorry,
Where is it written? Okay. Okay. Sorry.
requirements for a valid offer:
Hmm. Clarity, certainty, and this
clarity,
unintentional.
certainty, and display an intention to be bound.
Hmm.
These
Good point.
requirements are clearly illustrated in the case of Storer versus Manchester City Council, which can be contrasted in the case of Gibson the Manchester City Council. Now, these are two cases where the requirements of a valid offer they
Were
were
established.
displayed, and these conditions of clarity, certainty, and intention were all met
Hmm.
and were all discussed.
Hmm.
Now, these are the requirements for a valid offer. Now, what is an invitation to trade? If an
Invitation.
offer is made, the offerer is effectively undertaking to be contractually bound by the terms of that offer in the event of an unconditional acceptance being made by the offeree. So, number one, undertaking to be contractually bound. Number two, three, terms of the offer. Four, in the event of unconditional acceptance by who? By the offeree.
Hmm.
You have to meet five or four requirements. So, what are those requirements? The offerer is effectively undertaking to be contractually bound by the terms of the offer in the
Hmm.
event of unconditional acceptance being made by the offeree. An invitation to treat, on the other hand, now that is not this is an invitation to treat. An invitation to treat, on the other hand, is normally the first step in negotiations which may or may not lead to a firm offer
Hmm.
by one of the parties. Unlike an offer, it cannot be accepted to form a binding contract.
Hmm. Like again,
Invitation,
it's very clear that invitation to treat is something that is uncertain. First step towards negotiation. It can be accepted as a valid offer or not. It's just an invitation to read. However, an offer is like we have read clarity, conciseness, and something like it should be certain. On the other hand, invitation to read does not come with certainty, right?
yes, invitation to treat does not have certainty. That's the main difference between an offer and an
Hmm.
invitation to treat.
Hmm.
An offer, you have certain obligations, conditions, and specifications. In
Hmm.
an invitation to treat, it is just an invitation for you to be treated into an offer.
Hmm. Clear.
Invitation to treat are analyzed in the context of advertisements, display of goods for sale, tenders, auctions, and websites.
Hmm.
Now,
Advertisements
this
distributions.
forms part of a unilateral agreement.
Exactly.
You, so, first step for a unilateral agreement may be invitation to treat,
Yeah.
where you have display of goods for sale, you have
Hmm.
tender offers, you have auctions, you have website sales, and all of those kind of things.
Hmm.
Now, termination of an offer. An offer may come to an end by rejection or lapse or revocation. Three things. An offer can only come to an end by
Rejection,
rejection, lapse,
lapse,
or
or
revocation.
revocation.
In each case, the offer loses its legal effect and becomes incapable of acceptance. One of the elements is about termination of an offer. Counter offer extinguishes original offer. Request for further information, original offer remains open. Now, in counter offers, you have it. So, for example, you've seen a car that you like. You went to the seller and you he offers or he offers, for example, he says, I am going to sell this car for £3,000.
Hmm.
You look at the car, you get it tested, and then you speak to the buyer and you say, well, I'll buy this car off of you for £2,000.
Hmm.
Now that is a counter offer
Exactly.
which would
Distinguishes.
invalidate the original offer.
Hmm.
So now either he's got two choices. Now either he accepts your counter offer
Or rejects it.
or rejects it. If he
Hmm.
rejects it, the the the, the agreement is gone.
Documented.
If he
Hmm.
accepts it,
Hmm.
that is when you get into a binding contract.
Hmm.
Now, requesting for further information, what's the difference? Now, same car, I went to the seller and I said, okay, I'll buy the car off of you, but I need to test drive it,
Hmm.
or I need to know further information about its title.
Maybe who
What
holds the lease? Maybe who was it
maybe
that initially transmitted?
is this uh, car subject to a third party lease or a hire
Yeah.
purchase agreement or something like that?
Hmm.
So that is further, it does not violate the entire agreement.
Hmm.
It becomes part of that agreement. It becomes part of your investigation
Hmm.
when you're purchasing a property or when you're purchasing uh, a car or anything of that sort. Now that is termination of offer, and you've got two types of consequences for each. Number one is counter offer,
Hmm.
and number
And
two
further
is
request
request for
for
further
further.
information. Request for further information does not terminate the offer.
Well.
Counter offer would terminate the offer. Acceptance. Only the person, people to whom an offer is made, the offerees can accept the offer with.
Hmm.
Now it cannot be, if you are the offeree, if you are the person accepting the offer, then it cannot be your son, your daughter, your parents, your mother, your father,
Hmm.
your brother, anyone,
Hmm.
until and unless you have given them authority to do so. And
Yeah.
they are the authorized person to act on your behalf. Acceptance must be unqualified. It must be a mirror image of the offer, corresponding exactly with the terms of the offer.
Hmm.
So you cannot say that when you're buying a car, it's a Honda Civic
Hmm.
blue color.
Hmm.
You cannot, at the acceptance stage, accept a Toyota Corolla, which is
Hmm.
black color.
Hmm.
The offer was made for Honda Civic blue color.
Hmm.
So the acceptance should be for Honda Civic blue color. Manner of communication of the acceptance. Now, if the seller has asked you to email him, then you have to email him.
Yeah. True.
If he's asked you to WhatsApp him, so you
Hmm.
have to WhatsApp him.
Yeah.
If he's asked you to give him a call, you give him a
Hmm.
call.
Hmm.
If he's asked you for a letter confirming that this offer is accepted, you have
Hmm.
to write him a letter. Acceptance must be unqualified. It must be a mirror image of the corresponding exactly with the terms of the offer. And in that manner of communication, you have to mirror. So you've had a conversation over the phone. You've spoken to your friend and you said, "Oh, can I buy your car? This." And then you accept an offer for an XYZ car. You were going for an ABC car and you went for car XYZ.
Hmm.
And this is not a valid offer.
True.
An acceptance may be communicated in any manner whatsoever. However, if the offerer prescribes a mode of acceptance, either expressly or by implication,
Hmm.
and the offeree communicates his acceptance in a different mode, then this will raise the question whether the communication of acceptance in the other manner will suffice.
Hmm.
Now, if the offer was made via post
Exactly.
and and you've accepted the offer via a text message. It may be acceptable because you have used a very fast method, faster
Hmm.
than the method that was used previously or originally.
Hmm.
It may be accepted, but it is subject to some conditions. Now, what are those conditions? Was he expecting your message? What was the communication he was expecting? The seller was accepting or expecting.
Hmm.
Now, it is very subjective. That's why you need to see the way he has communicated his offer. Does he have a prescribed method? If he does, then you need to adhere to that prescribed method. Coming to number 4, acceptance must be communicated to the offerer. This rule raises several issues regarding acceptance communicated by post or instantaneous means, as well as whether it is possible for a contract to come into existence where a person other than the offeree informs the offerer of acceptance.
Hmm.
Now, imagine if you sent a text to person ABC. His or her daughter
Hmm.
XYZ
Hmm.
looks at the text and she replies, yes, agreed, with an emoji face.
Hmm.
Do you think that this is a valid acceptance?
Raise this question. Hmm.
It's not a valid acceptance.
What? Yeah.
How would we argue that? We would
Because.
argue that number one, the daughter was not an agent or authorized person to make or proceed with the purchase or sale. We had no communication with the daughter previously, and the term of the offer was communicated via the original offerer, not the daughter.
Hmm.
So, if the daughter does not form part of communication or correspondence, you can argue that the offer was not made. The acceptance is not it was
Hmm.
not in the prescribed manner and form.
Hmm.
Now you have to look at three things. Number one, prescribed manner, either by text, post,
Yeah.
telegraph, fax.
Hmm.
Then you have to look at what are you accepting basically with the seller. Specific term agreement. Number three, you have to look at who are you accepting it with? Does that person have significant control of the transaction? Number five is still open at times when the offeree accepts it.
Hmm.
If the offer has been terminated, for example, because the offerer revoked his offer, then the offeree cannot accept the offer. If the offeree has terminated, number one action by the offer offerer, that the offer that he made has been terminated by the offerer via revocation or rejection or whatever, then the offeree cannot accept the offer.
Hmm. Because it hasn't terminated or rejected or whatever.
No, because he has terminated that offer does not exist anymore. If you sell this pen to me, you say, Swan, I offer this pen to you for £100. But you have until tomorrow, 1 p.m., to confirm that you're happy to proceed.
Hmm.
I come back to you by 1:05, 1:05, and I say I accept your offer. Is that a valid offer? Is that a valid acceptance? No, it's not. Why? Because you have prescribed a time. Number two, where you take back the offer. You say, well, I mean, you've even if you've given me time and you say, I don't want to sell this pen anymore.
Hmm.
So even if I come back with an acceptance,
Hmm.
because you have taken back the offer,
Yeah, revoke the offer.
it does not exist.
Hmm.
So essentially, I am accepting something that does not exist.
Yeah.
Now, is the acceptance qualified? Does the acceptance mirror the offer? The objective approach to agreement. When determining whether an agreement exists between the offerer and the offeree, the court is not concerned with the inward mental intent of the parties. I, as the court, will not be concerned that person A and person B had the intention or foresight of doing something.
Hmm.
I would look at the actions of the party
Hmm. The objective approach.
because until and unless you have acted on your intentions, I cannot, I cannot, I can neither hold you guilty, I can neither hold you, I can neither bound you into a contract, bind you into a contract and say, well, I mean, you've made that contract because you've not. It was just your intention to make that contract until there is actus reus, the mens rea is ineffective basically.
Hmm.
When determining whether an agreement exists between the offerer and the offeree, the court is not concerned with the inward mental intent of the parties, but rather with what a reasonable man would say was the intention of the parties,
Yeah.
having regard to all the circumstances. In Storer versus MCC, 1974, Lord Denning said, in contracts, you do not look into the actual intent in a man's mind. You look at what he said and did. Said, again an action. Did, again an action.
Hmm.
Saying something, saying by words that I accept your offer. It is an action. It confirms your intent.
Hmm.
To sign an agreement, it confirms your intent. A contract is formed where there is, to all outward appearances, a contract. A man cannot get out of a contract by saying, I did
Hmm.
not intend to contract, if
Hmm.
by his words he has done so. So if I have said, I accept your offer, and now I'm refuting that offer, I'm rejecting that offer because I did not intended it, then why did I accept it?
Hmm.
The idea of offer and acceptance is that it shows a meeting of minds. But
Hmm.
the law applies an objective test when it comes to identifying agreement.
Hmm.
Number five, an acceptance may be communicated in any way whatsoever, but if the offerer has prescribed a mode of acceptance, either expressly or implication, the offeree communicates his acceptance in a different mode, then this
Hmm.
will raise the question of whether communication of acceptance in the other manner will suffice. Now, this is the repeat
Yeah.
basically. If the offerer makes it clear that he will not be bound unless acceptance is communicated in that precise way and by no other, then only acceptance by that mode will suffice.
Hmm.
However, unless the prescribed mode of acceptance
Sorry.
is made mandatory, another mode of acceptance, which is no less advantageous to
Hmm.
the offerer, will bind him. So, if, for
Again,
example,
we have discussed like if
yeah,
something is
if you
more.
send it by post and there is no prescribed manner, I can just send it by text, and that would be a valid accepted offer.
Hmm.
Acceptance, sorry.
Yeah. Unless it's like they have like they have communicated a specific mode.
Yes. Acceptance by post. The general rule is that is effective from the time it is communicated to the offer. However, where the acceptance is made by post, the acceptance takes effect from the moment of the letter of acceptance is properly posted. Now,
Hmm.
posted means that it is in within his mailbox. This is known as the posted rule, and the authority of the exception is the case of Adam v. Lindsell. The postal rule applies even if the letter is delayed or lost in the post.
Hmm.
Household fire and carriage accident insurance co versus grant. There are exceptions to the postal rule. If the letter was not properly posted, postcode is wrong, the
Hmm.
first line of the address is wrong, name of the person is wrong.
Hmm.
Number two, if it is not contemplated that the post would be used. If I have not contemplated it, if I have not agreed that post will be used, and I'm i- on a vacation, there is no acceptance of the offer. If the letter is incorrectly addressed, or if the offerer has ousted the post room,
Hmm.
I do not agree to the post room. So now you have to communicate or correspond with me in another method or form that we agree upon. Note that the postal rule does not apply to letters revoking offers. Note that the postal rule does not apply to letters revoking offers.
Just for the acceptances, right? When
Yes,
the when something is sent to the other party so that the other party accepts. It's not for when other party wants to revoke the offer, right?
yes. It is only for, I mean, postal rule only applies to acceptances of offer. Revocation can be done in any
Anyway.
way.
Hmm.
Usually, the quickest way is usually preferred. Acceptance by instantaneous means. The general rule for acceptance by instantaneous means is that the acceptance takes place at the moment it is received by the offerer. Antros versus MFEC, Miles Far East Corporation. In that case, Lord Denning outlined various scenarios which illustrate the receipt rule. When an acceptance is sent outside ordinary office hours, the question arises whether the acceptance takes effect instantaneously or whether it is deemed to have received at the start of business the next working day. The case of Mondial Shipping v. Astrid Shipping deals with a telex that was sent at 23:41 on a Friday, 2nd December. The court held that the acceptance was received at the start of business day on Monday, 5th December. The case of Thomas v. BPE Solicitors is important for two reasons. Firstly, the case established that an email was to be treated like other forms of instantaneous communication. Therefore, an email acceptance is effective when received. When the email arrives in on the offerer's email server. The second thing that the case established was that the meaning of ordinary office hours depends on the context of the party's prior communication. So if I was communicating with you at night as well, outside of office hours, the normal presumption would be that you would be able to accept my offer outside of office hours because you have created that presumption that you receive emails even at this time and you respond to them. But this is just in the cases of where offer and acceptance is in question.
Hmm.
This is not for general communication. So, this was agreements. So, we have covered six topics: invitation to treat, termination of an offer, acceptance. Is the acceptance qualified? Has the acceptance been made through a valid mode? Has the acceptance been communicated? And is the offer still open?
Open.